for judgment RFA 22 of 2019.
Yes. RFA 22 of 2019, this court is of the considered opinion that the respondent being hurt and grievance caused to him due to the incorrect score in the marks which were scored by him, that is from 65%, it was corrected to 82, isn't it?
Right.
And there is no explanation given as to why such wrong markings was given, which was more than 17 marks. Okay, so he is entitled to some compensation for the shock and the grievance that was caused to him. Okay. However, this court cannot simply, the presumption that he would have had a better opportunity had he had been admitted in St. Paul's Higher School is based only on presumption and assumptions. Okay. For that reason, the amount of compensation to be paid to him, the yardstick given in the cited case, that is Resident Board of School Education, etc. Taking that into consideration, which this court finds is applicable in the instant case, find that the compensation amount which was awarded to the respondent is slightly on the higher side, and therefore from 1 lakh rupees it has been reduced to 60,000. Rest of the judgment and order remains the same. Yes, disposed accordingly.
Applies. I may seek your lordship's indulgence in mentioning an unlisted item, part 2, my lords, actually. My lords, we are seeking a listing of a part 2 item. It's at hearing stage, so that your lordships may refer it for mediation, my lords. I had spoken to the
Okay,
other side.
mediation.
Yes,
Which one?
we want to give a chance to that.
Listed?
My lords, it's an unlisted item.
Okay. For mediation, so listed this thing on Monday.
My lords, your lordships.
What is it, this thing?
My lords, we have a land, my lords. That portion of land, my lords, the government has taken over, despite our rights being crystallized in an earlier proceeding, my lords.
So which is the matter?
My
RFA
lords,
what?
this is
When is it to be listed for hearing?
My
Which
lords,
week?
it's overdue, my lords. In fact, we had informed the registry to list it this week, but my lords,
Okay, listed anytime this week.
grateful. my lords.
Mention the matter, and then we'll make sure the counsel from the other side is also there.
It's Miss
Who is the
Linda,
counsel?
Miss Linda.
Oh, Miss Linda. Okay, listed sometime this week, and if find out whether they're willing to have the matter. What is this thing? Case number?
My lords,
Registered as?
petition number 20 of 2018 and
Okay, 20 of 2018.
and
So that
40
the,
of 2021.
okay, make sure that you know which is the case, what is it about, and get the necessary instructions beforehand so that we can list it for mediation if the respondents are also agreeable, isn't it? This week, anytime.
Grateful, my lords.
Lordship, I beg to mention item number 3.
My lord, I am also there in the item number 3, my lord.
Lordship,
Item
I'm
number?
responding to item number 3, Lordship,
3 of the which list?
of the daily list.
Daily list. What is it? 3.
Corresponding 2 to 5, appearing on behalf of Mr. S. Chetia. Due to some personal difficulty, the conducting counsel could not appear before this court today. Lordship, therefore, I'm praying if this matter may be listed after vacation, Lordship.
Okay, so is
My
the
lord, on
counsel for
19th,
the
my lord,
petitioner? Yes, you're for the petitioner, isn't it?
No,
Let the
I am for the petitioner, my lord. They are for the
Yes.
respondent.
And the other
Respondent
is
to
for the
default.
respondent. So you have prayed for Listing of the matter on which date? As per the
19th, my lord, 19th.
19th of
January, my lord.
January. Okay. On this, so we'll just make it on the submissions made by the learned counsels
Well,
for the parties. Okay. Matter be listed on 19/1/2025 due to the
19/1, 2026, my lord.
26, yes, on list on 2026. Okay. What is the
Well,
stage? What is the stage? Counter affidavit
My lord,
filed?
the pleadings are complete, my lord.
Okay,
We have
for-
also filed our affidavit. My lord, kindly just extend the interim order, my lord, till the next date.
Okay. So pleadings are complete. Is it for admission
Correct.
hearing?
Yes, my lord.
Yes.
For admission hearing. List the matter on 19/1/2026 for admission hearing. Meanwhile, interim order passed earlier shall continue till the next date of listing.
Grateful, my lord.
So
Grateful.
just make it on the submission made by the learned counsels for both the parties who appear through VC. Okay. Yes.
Grateful.
I do appreciate.
May I seek your lordship indulge in mentioning part 2 hearing item number 1 and 8.
1
with-
and
8.
8.
With the consent of the other party if the matter may be listed after vacation.
1 and 8. Okay. Is your name here in the cause list?
No, my lord.
Okay. Mention is made on behalf of Mr. F. Lal Engliana, learned counsel for the appellant for adjournment of the matter with the consent from the other side. In view of the above, list the matter after the ensuing vacation. Okay. 1 and 8. Same order.
For motion, item number 1.
Please, Lordship. Lordship, this is an electrocution case wherein the deceased Joshua Lalming Thanga died on 16 to 2016 due to electrocution, Lordship, while he was working as a laborer on the rooftop of the PhD department, Tui Kuat Lang, Lordship. And may take Lordship to page 21 of the writ petition. That is to whom it may concern, issued by the executive engineer PhED,
Yes.
wherein it says that Joseph Lalming Thanga was working on that very day, Lordship. And the police report is at page 24.
So have you approached the concerned authority?
Lordship, yes.
No. Where's this thing?
Also, but page 36 is the representation.
So what happened to that?
Lordship, page 36.
Any
is the-
response to that?
Yes, Your Lordship. Response is at page 39.
39. What did they say?
Also, they says that Power and Electricity Department is still in her standpoint as in civil suit number 36 of 2017.
What does
Also,
that mean?
Before coming to this honorable court, we have approached the civil judge, senior civil judge, and it was withdrawn with liberty to file afresh. Then it has come before your lordship.
So,
And your
it's
lordship,
still in her standpoint.
their standpoint is at page 43, your lordship. I have annexed in the.
What is?
This is the written statement submitted by the PNE department. Page 43, paragraph 17 is the relevant paragraph. May I read, lordship?
Yes.
With regards to the averments made in paragraph 11 of the plaint, the answering defendant submits that there is no cause of action in favor of the plaintiff and against the defendants. It is submitted that there had been a contributory negligence on the part of the deceased and he had consented to do work with the knowledge of the danger involved in the work and he did not take any necessary precaution.
So
It
this is the
also-
written statement made on behalf of the defendants.
Lordship, yes.
So what
PNE
happened to
department.
the civil suit?
Lordship, in the civil suit, here in that written statement, they say that it's not the fault of the PNE department. It's they accuse the PHE department because that was this is
Yes.
working.
So the matter. So what happened in the civil suit?
Lordship, in the civil suit, frankly speaking, Lordship, PHE department was not implemented as a party.
So you do that necessary in the civil suit.
Lordship, here we have make a party before this honorable court, Your Lordship.
It was dismissed or what? What happened?
It was not dismissed, it was withdrawn with liberty, Lordship. Liberty was,
Who filed this thing, civil suit?
civil suit is filed by the present petitioner, Lordship.
Then?
As a plaintiff.
You file afresh before the civil suit.
Lordship, though this honorable court had also a jurisdiction, Your Lordship, to entertain the case. And Your Lordship may take Your Lordship to page 24, which is the police report.
So, why don't you have the matter adjudicated in the civil suit, and if you are unhappy with that, you come to this court.
May take Lord.
Exhaust your remedy there first. Isn't it?
Lordship, but there are several cases also adjudicated by this honorable court. Since it may be true that the civil court may have a jurisdiction, that doesn't mean that this honorable court
What is the
not
amount?
able.
So there are many cases, even in other matters,
Lordship, yes.
where there's always a question whether they should exhaust their remedy first and then come to this court or not, isn't it?
Lordship, yes. And this honorable court also passed in the
so
another
you-
cases, which clearly says that, Lordship,
Give me that.
sure.
When they are, even in this thing, anticipatory bail matters, whatever, the apex court has held that they should exhaust their this thing remedy available to them.
Lordship, paragraph
On
number
this point,
23.
23.
23, second paragraph, Lordship. Further, it is true that the petitioner...
Wait.
Page
Okay,
23,
yes,
page
yes.
23, Lordship. Further, it is true that the petitioner could have a more comprehensive claim to civil suit, but that itself does not bar this court in exercising jurisdiction in this kind of cases. This has been accepted a principle of law, and I need not refer to any particular judgment or judgments, Your Lordship. So this is also electrocution case. And besides that, Your Lordship, there is no disputed question of fact. The police report is also very clear, which clearly says that there was a 5 feet high from the rooftop. There was a low-hanging 11 kV line.
Leave all that behind. But you see, when you have all this thing, first remedy available, even though a coordinate bench of this court felt that way, give me a more this thing, a more a judgment of the apex court.
Lordship, if
On
Your
this
Lordship thinks
issue.
that tomorrow I'll bring more
Bring it
citation.
tomorrow, okay. Because why burden this court when you have a remedy and you very well knew about it and you went and approached first, isn't it? In this case, you had gone to the civil court first, knowing very well that you could have approached that. And I don't know on what grounds you suddenly decided, okay, let's go. With a liberty to file afresh. That means the same court.
Lordship, yeah, though. Then I'll bring some more citation, Lordship. And Your Lordship also passed several cases in this
You see,
electrocution
but
case.
it will not be the cases where you had first gone to the civil suit and then withdrawn it with the liberty to file afresh.
And Lordship, as per my understanding, that does not bar this honorable court to exercise its
Get some
jurisdiction.
more judgments. Okay, and then we can
Sure, sure.
consider tomorrow.
Lordship, yes.
Okay, so I heard Mr. Johnny L. Tolson, Learned Counsel for the petition on the submission made by the Learned Counsel. This is the matter. Tomorrow's date on so and so. Okay.
Also by Lordship.
Item number 2.
Please, Your Lordship.
Yes.
My Lord, the petitioner herein is an lab assistant working under the Health and Family Welfare Department. Last week, similar nature of case, I have moved and Your Lordship had already issued notice. In this case also, my Lord, the
what
petitioner was
happened?
initially appointed as lab assistant on coterminous basis. Subsequently, he was regularized and then confirmed by the responding authority. Thereafter, he was also granted the financial gradation under the MSCP. But after rendering 15 years of regular service, the respondent had disputed his initial appointment, and thereby they have issued this impugned letter, my lord, which is at page number 66.
Now, what is page 66?
This is a letter directing the respondent authority to redraw the inter-se seniority list.
Okay, was that this thing? Inter-seniority list, inter-se seniority list,
Yes, my
has
lord.
that been drawn? Not
My
yet?
lord, in this case, they have drawn the provisional.
Okay, where's that?
Page number 16, my lord. Page number 16. In the other case last week, this is not yet drawn, but in this case, they have now made the
Okay,
provisional
drawn,
list.
and were you adversely affected by that?
Yes, my lord. If I may take a lordship to page number 67,
67.
office order dated 24/9/2025. This is provisional inter-se seniority list of lab assistant. And on the following page, my lord, annexure 1, they were arraying only 13 employees. And on the following page, at page number 69, annexure 2, I was placed at serial number 1, wherein I was remarked as withdrawn from the list.
Wait, this is, and during the month of February 2025, you are placed at serial number 1.
No,
Is
my
it?
lord. In the earlier,
You are who? You are serial number 1 of page 69, isn't it?
yes, my lord. Before that, my lord, if I may take a lordship to page number 47. 47. This is the then final inter-se seniority list of lab assistant issued on 2019.
2019.
yes, my lord.
So where's the 2019?
At 48, my lord, page number 48,
48 is the two.
47 and 48, it's a continuing letter. 48, the list, I was placed at serial number 3.
3.
Yes, my lord.
Then
And,
afterwards?
and thereafter, my lord, now the impugned provisional came, which is in page number 67.
Oh.
Earlier in the final, I was placed at serial number 3. And
Now
this-
you are placed where?
I was deleted from the list. Annexure 1, page number 68 is the list of employees,
Provisional Senior Laboratory Assistant as on September
2025.
2025. You are not there.
I was excluded, my lord.
Excluded. So yours is, then what is page 69?
69, my lord, if you see, look at the top of the page. List of lab assistant withdrawn from inter-se seniority list as per administrative letter 19/2/2025.
Okay, so you are not included. It's
Yes,
not
my
your seniority also, but you were not included in the inter-se seniority list.
Yes, my
So
lord.
where are you then? You have no seniority.
I have no seniority. I was deprived of my further future benefits, my lord. Nevertheless, I was already working as regular employee for the last 15 years. I have already been granted the first
Okay,
financial
so if your
accommodation.
name is not there, that means what? You will be dismissed or what? What happens then? Where,
They
where
have
do
not-
you stand?
That is one, my lord. They have not even taken any action against me, but I was just struck away from this provisional list. Even though I was already placed at serial number 3 in the
List
final
or,
seniority list.
withdrawn from intercessor as per administrative. Okay, where's the administrative department letter?
Page number 66, my lord.
66.
The allegation against me and other employees was that,
Okay, yours is okay because they're saying that yours is unauthorized
yes,
appointment.
my lord, that is the allegation
Oh.
against me.
So, but you have not been dismissed from service. You're still serving till date, is it?
I'm still serving, but
Getting your pay?
I'm getting my pay, but without any further benefits. I was already due for granting my second financial upgradation with effect from
Okay.
2021. So my humble prayer in this case is that, my lord, challenging the administrative letter dated 19/2/2025 as well as the provisional list. And besides that, I'm also praying for granting of my second financial upgradation.
Okay, so you want to be included your seniority in your
Yes, my lord.
seniority. Okay, well, show notice. Let's see. This is final interface seniority 48 as lab assistant. So here it is still lab assistant, isn't it?
Yes, my lord.
Oh, okay. Then later they found some They found that the appointment was this thing, unauthorized.
They are disputing as many as 600 plus employees initial appointment.
Anyway, let's see.
Yes, my lord.
Why is it disputed? Where's the appointment order? Let's see. Why is it said to be unauthorized?
My lord, I was duly recommended by the DPC since my initial appointment.
Oh,
And then thereafter I was regularized, and then thereafter was confirmed. It starts
so
from
where's your
page number
appointment?
28, my lord.
How is it unauthorized? Yes, page
Page number 28.
28.
This is my initial appointment recommendation of DPC. The DPC consists of the Secretary of Health and Family Welfare Department, Director, and representative of DPNAR as well.
Okay, so on careful assessment, Lalbiak Sanga
I'm on
appointed
the page number 29, para 2.
29. Okay. No, but yeah, okay, so on careful assessment,
Laldin Chua.
okay, Laltin Swa. On co-terminus basis,
Yes, my lord. That is the initial. And on page number 3030, this is my appointment order in
okay,
pursuant
this
to
is the
the
appointment,
recommendation of DPC on co-terminus
in
basis.
scale of pay.
And page number 31, this is my regularization order. Issued by the
Okay, will you
director.
show notice?
Yes, my
Let's
lord.
see what's going on. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India, arraying the office order dated, which is the first one? Dated 19/02/2025 and 24/09/2025, whereby the respondent authorities had found the appointment, had appeared to find, okay, the appointment of the petitioner as unauthorized appointment and had withdrawn the name of the petitioner from the list of the provisional seniority from the inter se seniority list as on September 2025. Therefore, stop. Then the learned counsel submitted that the petitioner was initially appointed as laboratory assistant, wide office order dated 11/10/2001 under the NIDDCP within brackets CSS close bracket on co-terminus basis. Thereafter, on co-terminal basis, on the recommendation of the duly constituted DPC held on 05/10/2001, full stop. Thereafter, his services was regularized, wide order dated 26/02/2010, with effect from 01/02/2010, and which was subsequently confirmed, Wide Office Order dated 22/02/2017, with effect from 01/02/2017. Full stop. The petitioner was also granted the first financial upgradation in terms of the MACPS 2010 with effect from 12/10/2011 on the recommendation of the Departmental Selection Committee. Full stop. The name of the petitioner was also shown in the intersive seniority list of lab assistant, Wide Office Order dated 12/09/2019, wherein the petitioner was placed at serial number 3. Full stop. The Learned Counsel submitted that while the petitioner was now due for the second financial upgradation, the respondent authorities had issued the impugned orders wherein the name of the petitioner was excluded from the list of the provisional seniority of laboratory assistant as on September 2025. Aggrieved by the said action of the respondents, the instant writ petition has been filed. Stop. This court find it appropriate to issue notice of motion to the respondents. Full stop. Ms. Linda L. Fumble, Learned Additional AG, accepts notice on behalf of the state respondents. No need to issue formal notice. Requisite extra copies of the writ petition to be duly furnished to the Learned Additional AG. List after 3 weeks. Yes.
The interim, my lords.
What is the interim?
The provisional may not be finalized
Okay.
or status quo may be maintained.
The Learned Counsel for the petitioner further submits that since the name of the writ petitioner has been excluded from the where's the
Page number 67. My prayer is in page number 24.
from the provisional seniority of the laboratory assistant as on September 2025, he prayed that this provisional seniority list may not be finalized since the petitioner would suffer irreparable loss if it is finalized, excluding his name. Full stop. Considering the nature of submission made by the Learned Counsel for the petitioner, the this court find it appropriate to stay the to pass an order that status quo be maintained till the next date of listing. Yes.
Deeply obliged.
Item number 4.
Yes.
Worship, we're still awaiting for the service against the respondent. But
Who are the respondents?
the one is the number one is the claimant and 2 is the owner of the vehicle.
So both of them?
Yes, both of them.
Where the same? What is the address?
One is the respondent number 1 is from Champai, and 2 also from the same.
Both from
locality.
Champai.
So,
And one was notice issued on.
we were waiting in the last.
So when did you
audit,
take steps for issuance of notice?
fresh step.
When did you take the first step? Initially, you took steps on when? You have taken fresh steps also.
No. We were waiting till now.
Return. So, do you want to take fresh steps?
Maybe we can wait.
Okay, we'll wait for some more time. If
more.
there's no response,
Yes, there is
because
no
you
response.
cannot, we cannot consider your
Or maybe we
appeal
can
in their absence.
ask the registry to track the.
We'll wait for some time. Consignment, there's already this thing, consignment tracking report.
I see.
Item dispatched. That's all,
Okay.
isn't it?
We have to wait.
So we'll have to wait for some time.
Yes.
If there's no this thing response or notice cannot be complete,
Yes.
then you consider whether you can serve notice through Dusty mode also.
We will.
Consider that in the
in the
meantime,
next day.
isn't it?
Yes.
Yes. Mr. Rosen Subedi, learned counsel for the appellant, is present. It is seen that service of notice upon the return of service of notice upon the respondents is still awaited. In view of the above, we may await for return of AD card, list the matter after the ensuing vacation.
I am obliged.
Item number 5.
Yes, what is the stage? What are we supposed to do?
On the last occasion, my lord, this matter was sent to mediation, for
mediation.
mediation, but they could not make any settlements between the parties.
Then we'll have to. So has the appeal been admitted?
My lord, in this case, during pendency of the appeal, the appellant in person had admitted his liability towards repayment of the decretal amount. So out of 18 lakhs, my lord, he had already paid rupees 10 lakhs, and 8 lakhs plus interest is still pending.
Okay.
Now he's changing counsel one after another.
Anyway, since there's no one to represent him today, we'll fix another. What's the name of the council now?
They're from
If he's
outstation.
changing his councils, who's the present council? 5 is.
Rupesh,
Oh, they're
Rupesh
on
Dutta.
this thing, not the local councils, it appears, and they're not here. So we'll wait for some time.
Yes,
Let's
my
see.
lord.
Mr. Victor L. Ralte, learned counsel for the respondent is present.
Number 1.
Respondent number 1 is present, while none appeared for the appellants. In view of the above, list the matter after the ensuing vacation. Yes.
I'm okay.
Item number 6.
His Lordship, in the last court order, I was directed to serve notice by way of Dusty upon respondent number 3, my lord. And my lord, the petitioners, the appellant's brother-in-law was suffering from severe ailment. my
Okay,
lord.
so you need further time.
No, my lord, due to that reason, my lord, notice was served only on yesterday. So, my lord, as such,
So you need some more time.
for filing affidavit, my lord.
Affidavit,
Yes,
isn't
yes, my
it?
lord.
Huh. Yes. So is your name in the cause list, Mr.?
Yes, R.L. Woodfella.
R.L. Rottweiler, learned counsel for the appellant, has prayed for further time to file his affidavit showing that notice was duly served to the respondent. To show that, okay, so in view of the above, list the matter after the ensuing vacation.
Yes, my lord.
Ensuing vacations.
Right.
Item number 7.
My lord, we have been given instructions that attempts have been made for amicable settlement outside the court. So if 3 more weeks may be given, my lord.
One indulgence, my lord. One indulgence, if your lordship kindly permit. Lordship, since the instant appeal has been filed in the wrong forum, in view of the Mizoram Civil Court Fees Amendment Act 2021, my lord, even in the absence, even if the instant with its connected appeal RFA number 2 of 2024 5 is dismissed, there is
Was
a
it the
chance.
wrong forum?
Yes,
My lord,
my lord.
What
The
is
Mizoram
this
Civil
thing?
Court.
Yes. What is the this thing amount?
8
8 lakhs.
lakh. Yes, my lord.
So appeal has to be before the district court.
Yes, my lord. So
We'll dismiss your RFA.
my lord, that
Even the limitation. If you're filing this
even
thing.
yes, even that is there, my lord. However, if 3 weeks time may be granted,
For
so that,
what?
so that my lord, without
You
instead of-
withdraw. You withdraw this
Instead of dismissing,
with
my
a
lord, if
permission
I may
to.
be allowed
You
to
withdraw
withdraw.
with a permission to file afresh. Okay, if so advised.
My lord,
Then in the meantime, see if you come to settlement, you withdraw because straight away you cannot have it appears from here 8 lakhs is the this thing suit amount. Then you have come to the wrong forum, obviously.
and my lord, there are costs as well.
my lord.
So cost is a different
Cost as well
matter.
as-
It is the thing suit amount that has to be looked into,
My lord.
isn't it? Yes, heard
that is there, my lord.
Mr. Atil Al-Zakima, learned counsel for the applicant, along with Mr.
Kevalan Lepuya.
Fadil Nekpuya, learned counsel for the opposite party. The learned counsel for the applicant has prayed for adjournment of the matter by submitting that the parties are making an attempt to come to an amicable settlement outside court. Full stop. While the full stop, then the learned counsel for the opposite party / respondent, on the other hand, submitted that the instant interpolatory application and the connected regular first appeal filed and registered as RFA number 2/2025 are liable to be dismissed since the suit amount in the connected civil suit number 107 of 2017 is how much? 8 lakhs something? I just saw it now.
Yes.
Yes. Wait.
816690.
Is 8 lakhs 16,690, and thus in view of the Mizoram Civil Courts amendment within brackets amendment 2021,
21.
the proper forum to file the regular first appeal would be before the district judge. Full stop. On considering the submissions made by the learned counsels, this court finds that since the amount involved in the connected writ regular first appeal and the civil suit is rupees, again 8 lakhs so and so. The appropriate forum which should have been approached is the court of the district judge. Accordingly, in view of the above, this court find it appropriate will dismiss the IA number 8/2025 with the connected RFA 2 of 2025 with an advice that if so, with an advice that the appellant should approach the correct forum if it so desires. This court, however, notes that the parties being what? Are they related?
No, my lord.
No, my lord.
Are they related?
They're not related.
Okay. That the parties finds that since it is submitted that the parties are trying to come to an amicable settlement, should pursue pursue the attempt to come to an amicable settlement.
Yes.
Yes, which would be in the best interest of both the parties. So accordingly, the RFA number, so the IA so-and-so along with the connected RFA so-and-so stands disposed of on dismissal. Yes.
It's like,
Part 2 hearing, item number 11.
Lordship, this RFA has been admitted on 15/5/2025 and TCR has been received.
who's the
However, we
counsel?
require a paper book, Lordship.
Paper book is necessary?
Yes, Lordship.
Why? What is the matter about?
This is about electrocution.
So you don't
Lordship.
have all the distinct documents in your appeal memo or what?
We have only the judgment, Lordship.
Who is the counsel for the opposite party?
Opposite party is for the state, Lordship.
State.
Miss Lalunloye.
Ah, she's not here.
She's not here, Lordship.
Miss so-and-so, learned counsel for the appellant is present and submits that though the TCR has been received, however, the paper book is required in the instant case. In view of the above, the registry to prepare the paper book at the expense of the appellant. List after the ensuing vacations.
Obliged, Lordship.